My name is Kai Birchmore. I'm a specialist in employment status and IR35. So effectively, whenever someone isn't on PAYE, I look after kind of that side of it, from giving companies advice to defending them if they get an inquiry from HMRC. And it can be anything from just giving advice to companies, reviewing how they work, reviewing how the people that work for them undertake that work, drafting contracts and so on. I've got quite a lot, I've given myself quite a lot to cover today, so I will try and get through it. Any questions, like I say, we can go through them at the end. But yeah, so the agenda today is to look at why is getting employment status and IR35 right important? What actually makes someone an employee? What is changing in April 2021, and who is liable and what are they liable for? So starting off with employment status. So when I'm talking about employment status, I'm primarily looking at self-employed workers, so sole traders, and whether they should, in fact, the revenue, if they opened an inquiry, could well argue that they should have been an employee of that company rather than self-employed. So the revenue are hot on this because they lose a lot of money, and I can pretty much guarantee if you get an inquiry and you're using self-employed people, they will challenge this position. This is slightly different to IR35, which I'll cover in a second, where you have people that work through their own personal service company, so their own limited company. So at the moment, when I talk about employment status, it tends to be your sole traders. I've put on here just a slide quickly just to demonstrate how much money the revenue can get off companies, just to highlight what a big issue it is. So if you're paying a self-employed person around £600 a week, the national insurance on that, the employer's national insurance alone, would be about £60 a week. HMRC can go back 6 years, so you're looking at about £18,000 for every person that you pay that's self-employed that HMRC argue should be employed. Ramp that up, if you had 15 subbies, you're looking at about 270,000, and then the penalties you would get tend to be on a percentage basis for this type of problem. So quite quickly, as you can see, all of a sudden your company's got this massive debt for an area that's known to be a complicated grey area of law, and yet you get heavily penalised for it. So there is quite a big risk there, but it is something that can be addressed and you can do something about. Even just understanding the basics of it, to reviewing it, you know, it already puts you in a better position. Comparing that to IR35, so IR35 is slightly different. That is when you have your company, your individual that works through their own limited company. Where that's the case, HMRC will ignore that limited company, and they'll ignore any agency or any other company in the middle, and they will focus purely on that relationship between the worker and the end client. They will then look at the way in which that individual works and consider whether that individual should have been an employee of the client. Where that's the case, IR35 would be deemed to apply, and additional tax and national insurance would be due, primarily because they would have been getting a tax benefit of dividends, which they shouldn't have been. So the key question then is what makes someone an employee or not, and equally by the same kind of question, what makes someone caught by IR35 or outside. There's no helpful definition in law as to what makes someone an employee, so you have to look at case law. Unfortunately, there's hundreds of judgments dating back over 100 years, so it's good fun picking through them, and it can be quite painful. But once you get to grips with the main judgments, it starts making more sense. So if you go back over 100 years, what made someone an employee focused purely on the level of control the employer had over that worker. In 1968, that changed slightly with a case called Ready Mix Concrete. And in that case, Lord Justice McKenna said that for it to be an employment relationship, there has to be a requirement for personal service. I'll go over these in a bit more detail in a second. there has to be mutuality of obligation, and there has to be a sufficient degree of control. If one of those aspects are missing from the relationship, that individual cannot be an employee. So they're kind of knockout blows. If you can demonstrate one of those, that individual is not your employee. And although the revenue might challenge it, as long as you can demonstrate that, you will win that argument. After the courts have considered those three factors, they'll then move on to anything else that is inconsistent with an employment relationship. So if we take each one of these in turn, I'll go over them quite quickly. So it is quite a brief summary. Obviously, they're a bit more complicated than what's contained in these slides, but I've kind of given you the bare bones to consider. So personal service, the key case from that was a case called Express and Publications and Tanton. In that, Mr. Tanton was a delivery driver, and he had got it agreed with the company using him that he could use anyone else to do the work on his behalf. He therefore didn't need to turn up at all, ever. He could literally arrange for someone else to do that work for him. And in that case, the judge in that case, this was a Court of Appeal case, and the judge said that if personal service is not required, then as a matter of law, the relationship cannot be one of employer-employee. So it's quite a clear statement. If you do not have to personally do that work, you cannot be an employee. So the best example of that is the right of substitution, which you may or may not have heard of. So if you can send substitutes in your place, then that's a good way of showing a lack of personal service. Equally, if you can hire help, or if the work could be subcontracted completely outright. So not just that you're getting someone else to fill in for you, but you're subcontracting the whole of the contract. If you've got any of those factors, it will help show a lack of personal service. There are a couple of points to note on that, however, or key points to note. If you're agreeing this in your contract, because that's the easiest way to show the courts that you have this right of substitution, because it's written in your agreement with that person, that agreement must be genuine, and the parties must expect that it can happen. It doesn't have to happen, so they don't have to send others in their place as long as they can, but that has to be a genuine right. So you can't just throw these clauses into the contract just for the sake of getting around it. Also on that note, there was another case, McFarlane, where they said you can send substitutes, but it has to be from a pre-approved list of people. We'll have an outright veto over whether they can do it. We'll arrange it and we'll pay for it. And the court in that said, well, they haven't got a right to send someone else. All they've got is a right to suggest that someone else can do it. And that's very different. So that's a real brief overview of personal service, but hopefully it gives you a flavour for what it means. The next one is mutuality of obligation. Now, this is the obligation on the employer to offer work and on the employee to accept work. The revenue don't accept this argument. They will argue that mutuality of obligation is satisfied if you turn up for work and get paid, but the courts have a different view. And this is seen most recently in the two cases, the 2020 cases, where they basically emphasised how important mutuality of obligation is. So yeah, if you're under no obligation at all to offer that individual work, and they don't have any obligation to do any work for you, then they can't be an employee. But that again is a harder argument to have with the revenue, because they don't tend to accept it. So that would be one that could potentially go to court to get resolved. The last key factor is that of control. So when we're looking at control, it's control over what work is being done, when it is being done, where it is done, and how it is done. The more of those you can demonstrate that you don't control, the better. So yeah, for example, if you're telling the individual, right, that's the job, just go and get on with it, essentially, then that's good. However, if you're supervising that position, making sure that they're doing it to the, how you want them to do it, then it starts becoming a problem. The important part of control to remember is that it is a right of control they'll consider. So it's not just whether you do exercise control over that individual, but whether you can exercise. And if you have that right to exercise it, again, then it becomes harder to show that they're not an employee. The last aspect is that it's a sufficient degree of control. So there will invariably be some parts of control in any relationship. For example, health and safety. There's always strict health and safety measures on sites, but they're there for different reasons. It's not because of the type of relationship. So the courts won't take that kind of aspect into account. Once they've considered those three factors, so you might have already won this case. If the revenue have challenged you, you might have already won it on one of those three, and that's really good. The last one you can fall back on is a bit more inconsistent and a bit harder to predict, and that is if there's anything else inconsistent with an employment relationship. Now, the way the courts approach this is if they get to this stage, they will say, well, we think they're an employee until you can show us enough factors that demonstrate they're not. And I've put on this slide a few different examples of what might show that someone's self-employed. Some will carry more weight than others. So, for example, if the individual has financial risk or spends a lot of money on equipment, then that's going to go a lot further than the fact just that they've got a UTR. A UTR doesn't really do much. All that does is show that they've registered to self-assess. Okay, so that is a real brief overview of like what makes someone an employee or not, and what you would have to argue with the revenue, and that applies whether they are self-employed or whether they have a limited company. The difference with the limited company contractors is at the moment, the way the legislation is worded, is that it's the limited company that would get challenged by HMRC. So when you're dealing with sole traders, it is the client that has to defend it and has to pay the liability. When you're dealing with limited company contractors, as of today, it's that limited company contractor that has to defend that position and argue it with the revenue. The problem the revenue have had with that is that very few people say, yeah, I'm caught by IR35, tax me like an employee, because why pay more tax than you have to? The revenue don't have the resources to open all these, hundreds of thousands of inquiries into each of these limited companies. So it becomes more onerous to start those inquiries. It takes a lot more time. Equally, it's quite difficult to get the liabilities, if the revenue win that argument, back off those companies. So what they are looking at doing, or what they are 100% doing from April 2021, is if you're deemed to be a medium or large company, the liability for IR35 will shift up and will become the client's liability. If you're deemed to be a small company, which I'll cover in a second, then the old rules still apply and the limited company contractor will be the one that's liable. However, that will probably change within the next year or two, and I suspect however you engage people soon, and not on your PAYE, you will have to have that argument with HMRC, and you as the client will be liable for that. So the starting point then to consider this new IR35 rule is your business medium or large? This legislation only applies, the change in legislation where you become liable for your limited company contractors is only if you're medium or large, and that follows the same rule as is set out in the Companies Act. And it's also the same rule as to whether your accounts need auditing. So if you satisfy 2 or more of the conditions in this slide, then you're deemed to be medium or large. So if you've got a turnover of more than 10 million, balance sheet of more than 5.1, and 50 or more employees, you're deemed to be medium or large. If you don't have that, you're deemed to be small, and the old rules will continue to apply. So with these new rules, if you are deemed to be a medium or large client, or if you're effectively like a recruitment agency supplying people up to a medium or large client, then the responsibility to determine an IR35 and employment status effectively of those individuals will rest with the client, and they will have to determine and tell the next people in the supply chain, whether that be the personal service limited company or an agency, whether IR35 applies or not. So at the moment, it's the limited company's decision, whereas from April, it won't be. It will be the client that has to decide that. And they have to take reasonable care. They can't just say, yeah, everyone's caught by IR35 or everyone's not. They should consider that position for the limited company guys. They then have to, as a client, issue a status determination statement, and this is just a document that says whether they're caught by IR35 and why or why not. This enables the individual to be able to appeal that. And the client has to supply that document down the chain to the next person in the supply chain, like I say, whether that be an agency or the personal service companies themselves. If the individual or the agency just decides to dispute that and says, well, do you know what, I believe that IR35 does not apply, then the client has 45 days to reconsider that position and issue a new status determination statement. There are then obligations on the fee payer. So if the client pays someone through a recruitment agency, as long as the client has met these conditions and complied with these, the liability and the responsibility all moves down to the recruitment company or other intermediary they're using. So from a client's perspective, as long as you can tick each one of these off, then at that point it's no longer your issue and it's for someone else to deal with, unless you're paying that limited company contractor directly. So there's different ways you can tackle this. You can review the position. So the revenue have got their own check employment status for tax tool. I do not recommend that at all. It is significantly biased towards finding people as employees. For example, it doesn't address mutuality of obligation at all, even though its cases are won on that area all the time. The questions on control aren't correct. It says, for example, that control over how the individual works is irrelevant if they're skilled. Well, that's not the case. So things like the employment status tool that the revenue use and online questions, they can be kind of handy to give you a snapshot of where you sit, but I would always encourage looking into it in a bit more detail. You can review the contractual position. The contracts form the backbone of any defence against HMRC. If you're trying to show that you have no right of control, the easiest way of showing that is in a contract between you and the worker. So always make sure that you have a contract with them and make sure it is watertight from this kind of perspective. Naturally, you can train yourself on IR35, so doing things like this will help give you hopefully a bit more of an understanding on these issues, but equally, you know, we could look at doing more detailed training and things like that so you get that you're accustomed to it and you're happy with that position, or you can use companies like ours to consider this position for you. So the options going forward, you could think, right, well, this is too much risk when we're going to put everyone on PAYE. The problem with that is that it is very expensive. You've got obviously employers' national insurance, holiday pay, pensions, employment rights, and equally your workforce becomes quite inflexible. So this is often a knee-jerk reaction people might have, but there are, like I say, as long as you consider this area properly, there's no reason to really panic. You can consider IR35 employment status. So again, a bit more of a detailed look at how you work. Make sure that that you're not that exposed to any risk, or you know, there is always that risk element to it, but you can really reduce and control that risk. At least then you're going to keep those individuals happy, so they're going to carry on working, and hopefully they won't down tools and leave if you tell them, right, you've all got to go on PAYE. So it keeps your costs down as well. Alternatively, you could use an intermediary, so like a recruitment agency or a payroll company. This does provide a buffer because they become the fee payer. You just need to be careful who you choose and make sure that they know this area, they've got a lot of experience in this area and know what they're doing. This does obviously cost money, but it would be significantly cheaper than PAYE. So they're the kind of main options going forward. I feel like this is the quickest I've ever gone through employment status, so hopefully you've been able to keep up, but as I've put on this slide, stay calm, don't panic. It is a complicated area, but there's no reason you can't go through it and make sure that you're in a good place, that if the revenue do make any arguments or challenges, that you're able to deal with it. Yeah, I've put in here, I wrote a book for Bloomsbury Publishing this year about off-payroll working. It's not the most enjoyable read unless you really like this subject. It's quite a dry topic to read a whole book about tax, but it's you know, if you're really loving it, then that's always an option. But yeah, I will leave it there for now. That leaves 5 minutes, I believe, for if anyone's got any questions. Yeah, and I'll hand you back. Well, I'll answer any questions you've got.
Thank you very much, Kai. Thank you very much indeed. Yeah, this is a great opportunity now. If you've got any questions that you want answering, we're on the conversations stage, so it's encouraging to embrace that. So do fire any questions that you do or may have at Kai.
Only mic is on.
Yeah, exactly.
Yeah, people are usually reluctant to ask.
Yeah, don't be scared. It's quite funny, Kai. You mentioned about you wish you'd never asked before we kicked off, and it's amazing. I guess that's why we've got experts like you that we can kind of look out for, or reach out to, and yeah, kind of navigate us through that ever-changing landscape as well.
Yeah. Oh, it's yeah. It keeps me busy.
You mentioned a date. Actually, I've got a question. You mentioned a date about the client liability. When was that date again?
April 2021.
Okay.
But that's only if they're limited company contractors.
Okay. Yeah.
Yeah.
Okay. Any questions from anyone else? No. You've been let off lightly, Kai.
Yes, because everyone's like, I don't want to talk about that anymore. Move on.
Kai, I just going to say it's a really complicated area, isn't it?
It is, yeah.
And to the ordinary layman, you really need to get your head around it.
Yes.
I won't promise to read the book. I don't understand it, but well done. I thought it was a very good overview this morning. Thanks.
That's all right, thank you. Yeah. Obviously, my details were on the first slide. I don't know if they get a copy of that today, but
yeah. Well, Kai, you can, but by all means, pop it in the chat if you like. Okay.
And then if anyone too shy to ask a question or thinks of something later, yeah, by all means, drop me an email and yeah, I'll get in touch.
Yeah. Yeah, do pop it in the chat, or if you want to just share your screen again on the first slide, if you like, for those people that want to take your details down, that might be quite advantageous.
Yeah, so it's yeah, it's on this one here, not that one. Let's go all the way that one. So yeah, that's my email address if you want to jot it down, and then any questions that you think of at any point, whether it be that you just want to have a quick chat and make sure you're okay, or yeah, always happy to help.